Okay, welcome. My name is Noelle Hicks. I'm a shareholder with Roberts Markel in our Houston office. And today I'm going to be talking a little bit about the role and importance of governing documents. This is probably going to be a bit of a shorter presentation based on the information that I have to present for you today, but it's timely and really important given the fact that we are just coming out of a legislative session and there are quite a bit of new laws that are going to take effect September 1st. And so, of course, with that, there are going to be a couple of policies that we would recommend. So today we'll talk a little bit about governing documents in general, hierarchy, and that sort of thing. I'll talk about the agenda in just a second, but most importantly, we're going to get into the importance of policies, why we do them, what they do, how they kind of, affect an association. And I'll give a recommendation at the end about what sort of policies that we're recommending for this year. So, of course, with all of our presentations, we have a disclaimer. The information that we're presenting to you today is the law as it exists as of July 22nd, 2025. And of course, as a reminder, this is going to be presented to you just for educational purposes. It's not legal advice. But if you have any questions about any of the things that I talk about today, please make sure to reach out with a question. There'll be some time at the end for some questions, but if anything comes up afterwards, you can feel free to reach out to me. My contact will be at the end of the presentation. So for our agenda today, we are going to start out by talking about the hierarchy of governing documents. This is going to be important because it'll kind of put some things into perspective about the different documents that you might encounter in your day-to-day activities as a manager. We'll also talk about how documents get amended. That can differ from one document to the next. As I mentioned, we're going to talk about the importance of policies, and then we'll get into some of the recommended policies for the 2025 year. All right, so first let's talk about the hierarchy of governing documents. And with this, we're going to start off by talking about a plat. As you know, a plat is the map or kind of like the framework for the community. It's going to set forth the boundaries for the lots. It'll let anyone who's reading it know what the setbacks are. It will map out the streets, the association's common area, and any easements like a utility easement or anything like that. The plat, once that gets recorded, is really the most priority document for a community association. And a lot of times in those plats, if you look at them, it will let someone who's reading it know that this is a deed restricted community. Now, of course, it won't set forth what those restrictions are, but it will say, this is a restricted community, and it might reference a governing document, maybe not, depending on when it gets filed. But that should certainly be the hierarchy or the most priority document that we look at. So, for example, if we have a situation where we're trying to figure out where the lot lines are, a lot of times people will want to go and take a look at the CAD, or maybe they'll look at a survey. But really, the plat is the document that you really should look at. That's the one that's going to control what those lot boundaries actually are. This will be very important for things like a dispute related to a fence, maybe an association fence versus a homeowner fence or something like that, right? Of course, the plat needs to be recorded with the county where that property is located. If it's not recorded with the county, then it's not effective. So all of the documents that I'm going to talk about today, and I'll reference the code sections in a moment where it shows that that needs to be done. But all of the documents that I'm going to mention today must be recorded or filed in the real property records of whatever county that the community is located in. So the next most important document, or the next document in the hierarchy, is going to be the declaration. Now, there is some debate about whether or not the declaration should actually be the next most important document between that and the certificate of formation. But we'll go ahead and talk about the declaration, and then I'll get into the certificate of formation on the next slide. So the declaration is the instrument that gets filed in the real property records of, again, whatever county that the community lies in. And that's going to include all of the restrictive covenants for the residential subdivision. Now, this is going to be true for both a single family or a condo or even a townhome community. That declaration is going to contain the use restrictions. It should also contain the information related to assessments, and it should also create the association's lien on the property for the assessments. It should also let anyone reading know what is secured by the association's lien, It might also give some information about the association itself, any easements, certain responsibilities of the association versus homeowners, certain things like that. And then obviously it's going to contain the information about how that declaration can be amended. So there's a distinction to be made between the declaration and the bylaws. A lot of times people will refer to the bylaws, and what they really mean is the declaration. But those are two very distinct and separate documents. Again, the declaration is going to have the information about use restrictions, the restrictive covenants, any information about assessments, whereas the bylaws, which I'll talk about in a second, really deal more with the governance of the association and the board itself. All right, so let's move on to the next slide, where we'll talk about a couple of other documents in this hierarchy of governing documents. The next one we'll discuss is the certificate of formation, or the articles of incorporation. So generally, associations are incorporated as a nonprofit corporation in Texas. And so the certificate of formation is a document that gets filed with the Secretary of State. It creates the association. It sets forth the purpose, the name, and the initial board of directors, and some other very important information. Now, as I mentioned on the last slide, some may say that this one could take hierarchy over the declaration if it's recorded sooner. And most times when you're kind of going through the chronological order of how these documents get filed, the plat will get recorded first, and then the association has to be created. So the certificate of formation will be created next and then recorded, and then the declaration will come about. So it really depends on the sequence of things, right? Depending on what the hierarchy is. Now, the certificate of formation is really just forming the entity. It doesn't have any information regarding the restrictions or anything like that. So those are still going to be found in the declaration. But again, it really just kind of depends on the chronology of how these things get filed. And that will depend on the hierarchy. So a couple of other documents that I'm sure that you've seen in your everyday practice. I mentioned the bylaws. That provides the framework for the corporate governance, or how the corporation itself, how the community itself is going to function. So in the bylaws, you'll find information like meetings, how the meetings should be run, how often they should occur, notice requirements, what the quorum for the meeting should be. You'll also find information about election of directors, the different positions on the board, the powers and duties of the board, and then any officer responsibilities, and so on and so forth. So all the things about how the association should be run are going to be found in the bylaws. Now, there are sometimes other documents that you might find that control the association. A lot of times you'll see architectural guidelines or builder guidelines. Those will be the documents that show, the different aesthetic related things that a homeowner can do when they're having some sort of exterior maintenance or exterior improvement on their property, or perhaps even a new construction. Rules, regulations, and policy, these are going to be the documents that provide a little bit more detailed procedure for enforcement of specific restrictions. So a lot of times the restrictions themselves can have some holes, or they may be a little bit vague. And occasionally it's important for us to create rules and regulations or bylaws to kind of fill in those gaps and give more focused information on a specific topic, so that it's less complicated or less confusing for a homeowner to do something, right? So for example, you probably have heard policies related to solar panels, or something of that nature. Or perhaps you have a policy that is related to collections or finding and enforcement, right? Those are some things that are probably not going to be contained in the restrictions. Now, the restrictions will say that the association has the authority to collect the assessments, or it has the authority to assess or levy a fine, but it doesn't give you the procedure on how that should be done. And for example, it doesn't tell you how many notices should be sent, or it doesn't tell you, the timeline or the deadline that the notice should give, or an opportunity to cure, or anything like that. So not only is that helpful, a policy or some rules and regulations helpful for the community to run more smoothly, but then it also kind of gives black and white information for a homeowner, so that they can go to that document to figure out how the association is going to do certain things or what procedure the association is going to use for certain things. And the one that comes immediately to mind, obviously, is the collection or finding and enforcement policy, because we do quite a bit of those. Now, there are also different hierarchies as far as statutory law is concerned. Obviously, community associations or property owners associations are governed by the Texas Property Code. For single family, we use Section 209. For condominium associations, we use chapters 81 and 82. And then there are other provisions within the Texas Property Code that are relevant. Those are state laws, but there are also federal laws that are related or that govern community associations as well. And so the one that's coming to mind for me right now is the Federal Debt Collection Practices Act. That's a law that we have to take into consideration when we are doing collections. And then there might also be some local laws, some ordinances that we have to kind of look at that might govern the association as well. Those are obviously going to be specific to whatever city or state or city that you're located in, or whatever county you might be located in. But just keep in mind, federal is the one that takes the most priority. Then we'll look at state, and then local would be the last one on that list. All right, so how do we amend these documents? Now, this question comes up quite a bit because there would be provisions in the bylaws, for example, that might need to be updated, or they're not relevant to an association anymore, or even there might be a situation where the association needs to add a restriction to its governing documents. Well, if we're talking about the articles of incorporation, typically 2/3 of all the members are required to approve an amendment of an article of incorporation or certificate of formation, unless the declaration provides for a lower number. You don't often see a need to amend the certificate of formation, but if that situation arises, then you know what you need to do that. And that 2/3 is something that kind of is a very similar theme throughout a lot of the other documents. So for the restrictions, for example, for both single family and condominium associations, it's 67% of all owners. Now, for single family, there's a bit of a distinction. It's 67% of all owners or lesser percent if the declaration contains a lower percentage. And then for condominium associations, it's 67% of all owners or a greater percentage if the declaration contains a higher percentage. So generally, condominium associations, you won't see anything less than 67%. Single family, you won't generally see anything more than 67%. Now, there are exceptions to that. I have seen some documents that might require 75% of all owners or something like that, but those are rare. Still, 67% is a pretty high threshold, especially if you have a larger community or you have a community that has very little engagement. So this can often be kind of a prohibitive provision. But it is one of those things that if the association has something that it really wants to change about the restrictions, then there's work that can be done in order to get that amendment approved. One of the amendments that we see most often that associations are attempting to pass or get approved is an amendment for leasing or short-term rentals. That one has been really popular over the last several years. And I have seen several communities kind of come together who are all basically sick of, short-term rentals kind of taking over their community. And they have been able to accomplish getting approval of 67% of the owners in order to amend the documents to include that. So it is something that can be done. But again, it is very difficult. Now, for the bylaws, generally the bylaws will also have its own amendment provision. The restrictions usually say 67%, like I mentioned. The bylaws sometimes will say 67%, sometimes it'll be less. But there also might be an opportunity for the board to have the power to amend the bylaws regardless of what it says. I'll get into that in the Texas Business Organizations Code in just a moment to kind of inform you on how that could happen. But again, the bylaws will generally have its own amendment provision. Now, when it comes to architectural guidelines or builder guidelines, or even rules and regulations and policies, generally the board has the power to amend both of those kinds of documents without any input from the membership. that should be one of the powers that's bestowed to the board in the bylaws. And even the property code allows for the board to have that sort of power to do that. Now, keep in mind that any sort of restrictive covenant or governing document generally has to be amended during an open board meeting. So remember those provisions if the board is attempting to make these sort of changes. It's a very good idea to reach out to the association's attorney to help you along with that process and kind of walk you through that process if you have any questions. All right, so there are provisions that we can kind of look to in the property code to help us with adopting or amending certain dedicatory instruments. So if we look at section 209.0041, that's one of the sections that we look to get the authority to amend certain dedicatory instruments. That's going to be the one that specifically spells out that it needs to be 67% of all ownership in order to approve an amendment. Also, that's going to require a community vote, right? So if you're putting forth an amendment of a governing document, it's going to require an association vote. So keep in mind section 209.0056 and the notice requirements for an election or an association vote. Remember that if you're going to have any sort of election or vote that's not taken at a meeting, then the Property Owners Association has to give 20 days notice of that vote or election to all owners that are entitled to vote. It's a little bit different if the vote or election is going to be taking place at a meeting, but just keep in mind those distinctions. And again, if there are questions, reach out to the association's attorney. It is a little bit different for condominium associations. So if the condominium is an 81 condominium, which it means it's before 1994, then you're going to look to section 81.111 of the property code. If it was formed after 1994, then you're going to look at section 82.067 of the of the property code for the amendment provisions. And then also, if you are concerned about any questions related to a meeting at which amendments may be adopted, then the provision of the property code that's relevant is section 82.070. Again, those are for condominium declarations or amendment of any sort of dedicatory instrument related to condominiums. All right, now let's talk about bylaw amendments. So before I mentioned that bylaws have their own amendment provisions, but there might be some room for a board to amend or repeal or adopt new bylaws under the Texas Business Organizations Code. Now, it's really important to look at the language that's in the current bylaws, the amendment provision, because the language there is very important as to whether or not the Texas Business Organizations Code would be relevant. Sometimes that language will say something like, these bylaws may be amended by the membership. And that sort of permissive language would allow us to go and use section 22.102 of the Texas Business Organizations Code. But if there's more mandatory language, if it says anything like shall or must, then this section probably would not be relevant, and you probably would have to go along with whatever the amendment provision is in the bylaws. So if it says something like shall or must be amended by 67% or 2/3 of the membership, then that's the route you have to go. There are also certain exceptions, as there are with every law pretty much. And those exceptions are if the certificate of formation reserves the power exclusively to the corporation's members, if management of the corporation is vested in the corporation's members, which is usually not the case for any of the associations that we represent, and if in amending, repealing, or adopting a bylaw, the members expressly provide that the board of directors may not amend or repeal the bylaws. So, of course, these are exceptions that the association's attorney needs to take into consideration when they are giving out advice and letting the association know whether or not this particular section would be relevant. But again, the original language in the bylaws or the amendment provision, it's what's really important. Now, some things that we can look to amending in the bylaws or things that we typically see are quorum. A lot of times associations have a hard time meeting quorum, and so they're not able to have their meetings at all. And if that is an issue, and specifically not necessarily the open board meetings, but specifically their annual meeting or any member meeting, this is the thing that really affects a member meeting quite often. Quorum can't be met because there's not enough participation from the membership. And so the meeting can't be held. And if an annual meeting can't be held, then there can't be an election, right? So if possible, the board might want to take into consideration reviewing the bylaws to determine if it's a good idea to maybe amend the quorum provision. And a lot of times too, the terms of the director provision in the bylaws makes things a little bit more difficult. We like to see kind of a staggered bylaw provision, and a lot of times the bylaws don't have provisions like that. It just would say, a member can become an officer on the board, and that term will last for 2 years. And then at the expiration of that 2 years, then there will be an election. It's good to have a staggered term for the board, because that will leave some members on the board. So when there are new members, they can assist in the training and kind of helping along of the new members. And there's never a gap or any sort of separation between the boards. And that way that there's a constant education and a constant kind of assistance between the board members so that people aren't starting from fresh all the time. So these are some things to consider. I've had quite a few associations reach out because they're having issues making quorum and unable to actually have their meetings, and so elections can't be had. And when that happens, a lot of times the members don't really understand why the election can't be had, and then it turns into a whole situation, right? They get upset because there's no election and the vote can't be held, and so on and so forth. So if there is a way for us to correct that, then we should kind of look into doing it. But again, this is something that the association's attorney really needs to review very carefully before it can advise the association on how to proceed. All right, so in order for a governing document to actually be enforceable, then it has to be recorded in the real property records. I mentioned this before, but this is something that's really important because you have no idea how many times we have associations present us with a document that has a provision in it that they want to enforce against a homeowner who is in violation of that provision, but the governing document itself has not been recorded in the real property records. And as a result, it's not enforceable. And once it gets recorded, so let's say, for example, in that situation, I get the document, I say, oh, I don't see a file stamp on it, so I know that it hasn't been recorded in the real property records. Once it gets recorded, I cannot then retroactively enforce it against a homeowner because it becomes effective as of the date that it was recorded. So it is very important to make sure that any document that the association intends to use as an enforcement mechanism is recorded in the real property records. Like I said, like it says here from chapter 202.006 of the property code, a dedicatory instrument has no effect until the instrument is filed in accordance with this section. There's also another provision in the property code, it's in chapter 5, that requires that governing documents or a dedicatory instrument is filed in the real property records. So this is a very, very super important provision that we all need to remember. All right, so somewhat recently, there's also a new requirement for governing documents to be online. So section 207.006 of the property code requires that if an HOA is at least 60 lots or more, it has to, or it has retained a management company. So that's an or, right? Either more than 60 lots or has a management company. Then the association must make dedicatory instruments available to members on a website. That's mandatory language, not permissive. So that is a requirement for the association to have their governing documents available online to their members. Now, I get this question a lot. Does this mean that the association has to make a new website that's available to people? Or for those of them that are using things like Town Square or some other management related website, if the documents are available on a website that's specific for the community that's kind of umbrellaed under something like Town Square, that's perfectly fine. The provision requires that the dedicatory instruments are made available to members, not necessarily to the general public. Now, there are a couple of things that are relevant with regards to enforcing governing documents. Obviously, the functions of the association that should be contained in the governing documents, and if they're not, this is something that's also can be found in the Texas Property Code. But some of the functions of the association are preparing and adopting budgets, setting and collecting assessments, enforcing restrictions, keeping up and maintaining common areas, so on and so forth. These are all manners in which the association enforces governing documents. It's all functions of the association, powers and duties of the association. And so if those documents are not recorded, and now if they're not kept on a on a website for the members to be able to reference, then the enforcement ability is lessened or weakened. So we got to make sure that the association is keeping up with those rules. And as managers, that's something that you need to make sure that you remind the association of that they have to do. And if you find that there's some document that they have that hasn't been recorded or has not been uploaded to the website, make sure you inform them, but also let the attorney know so that we can make sure we get that recorded for them. All right, so obviously, also with governing documents, the declaration itself is the thing that contains the restrictive covenants. The restrictive covenants can do a couple of things, right? It can let a homeowner know what is permitted on their property and also what's prohibited on their property, right? In addition to that, the restrictive covenant is also going to let the homeowner know what person or entity has the right of enforcement. Now, this is an interesting topic because a lot of people are not aware, but not only does the association have certain enforcement abilities, but individuals do as well. And we'll get into that in just a few moments. So here are some examples of restrictive covenants, things that can be enforced that will be found in the declaration. Because again, remember we said that the declaration is the document that houses all of the restrictive covenants. So examples can be things like prohibiting non-residential uses of property. So any commercial use or business use is usually something that's prohibited by the restrictive covenants. It can also prohibit multifamily occupancy. So anything like a duplex or multiple families, renting rooms, Airbnb, short-term rentals, things like that, those can be prohibited by the declaration. It may also require certain improvements to be maintained. So this can be something like a fence on someone's property, or it can be something like painting the front of the home, making sure that there's no grime or mildew building up on the surface of the property or the residence. And it can also require architectural review. Now, this is really important too, because the governing documents or the restrictive covenant should create an architectural review authority and then bestow that authority to a committee or something similar, right? There are documents that I've seen in the past that do not actually give any architectural review authority to a committee or don't create that authority at all. So it's really important when there is an architectural review committee that we confirm that there's architectural review authority and then make sure we know exactly what that looks like. And then the committee itself needs to very closely review any architectural guidelines and in also the use restrictions in the declaration to make sure that whatever applications are being submitted for any sort of improvement, exterior improvement on a property or on a residence, that if they're going to approve it, the approval falls in line with what the documents require, what the aesthetic of the community looks like, so on and so forth. That's really important. All right, let's move on and we'll talk about enforcing the governing documents. So I mentioned earlier that the declaration will inform us how the restrictive covenants can be enforced. And of course, the association has the authority to enforce the governing documents, but owners can also enforce the governing documents. They usually have that right, and that enforcement provision will be perhaps somewhere in the miscellaneous section, or maybe there's a specific section referencing enforcement. This comes into play a lot of times with neighbor to neighbor disputes. and their right is going to be inferior to that of the association. So owners do not have the right to try and collect assessments. That is a right that's reserved only to the association. But what they can do is try to enforce the restrictive covenants themselves or the use restrictions themselves. So in a neighbor to neighbor dispute situation, let's say that there's some issue about a fence maintenance, and the owners are having an argument about how the fence is supposed to look, maybe what kind of wood is supposed to be used, the height of the fence or something like that. That would be a good time for them to go and look into the governing document, maybe the declaration, or even any architectural guidelines that might be on file to see what the requirements are for this particular community. And then they should be able to come to some sort of agreement about how to replace that fence or how to maintain that fence in accordance with what the restrictive covenants are for the community. Now, if there's a dispute, obviously, then neighbor A might be able to hold neighbor B accountable for fixing this fence or assisting with fixing the fence by using the governing documents, and they might be able to go and file a lawsuit in the county where the property is located to enforce that specific provision. I don't see that happen very often. A lot of times neighbors are not willing to spend their own money to take another neighbor to court in that way, but it is an option that's available if a owner would like to take advantage of that. All right, so we've talked about the hierarchy of the governing documents, amending the governing documents, how to enforce governing documents. And now I want to talk a little bit more about policies and why they're so important. Earlier, I mentioned that the purpose of a policy is to kind of fill in gaps and provide clarity of certain provisions that already exist in maybe the declaration or in the property code. Policies are also very useful for taking some new law that's been instituted or that's going into effect and making it relevant specifically to the community that you live in or that you are assisting with managing. So it really is a good opportunity for the board to assess any changes in culture and technology, but also changes in the law. Changes in the law generally reflect changes in culture and technology as well. And then it's also going to assist in the enforcement of restrictions. And ultimately, the whole point of a property owners association is the protection of property values. So policies certainly assist with that as well. And if you think about it, there are certain provisions in the property code that require an association to record a policy for certain things. So for example, having access to the books and records of the association or the ability to copy or produce those documents, those are things that are required to have a policy in place. If the association does not have a policy in place, then it cannot charge a homeowner for copying fees or anything like that. So the property code is very specific about certain policies. Others are discretionary, but with the recommendation of the association's attorney, you should be pretty equipped with what sort of policies would be relevant to the association that you're dealing with. All right, so another thing I kind of wanted to mention before I get into the recommendations for 2025 is that policies are not intended to create or expand new rules. There was quite a bit of case law that has come out over the last couple of years where it was relevant to short-term rentals, where associations were attempting to regulate short-term rentals by creating a policy, but there was no authority in the declaration for any sort of regulation of short-term rentals. And courts in Texas have pretty much ruled that the best and most effective way to regulate short-term rentals or anything like that would be to amend the declaration and not to create a policy, because the policy obviously doesn't carry as much weight. It's not as effective, and you cannot create rules with a policy that do not already exist in the declaration. Instead, the policy is intended, as I mentioned, to fill in a gap and provide clarity of things that already exist in the declaration. So let's keep that in mind. We can't create policies where there is no original authority in the declaration. All right, so what are the recommended policies for 2025? As we all know, we are just out of a legislative session. And a lot of new rules are going to go into effect in September 1st, to be exact. And so there are quite a few policies that we recommend from rules that came out of this legislative session. So there's one related to common area usage that would be very important for communities that have common areas. This one's going to be related to allowing certain political figures or local people to come into the community and meet or speak to members of the community. They are supposed to be following the same rules that any community member would have to follow for rental or any fees that are associated with using that area. So a policy is recommended to put in place so that everyone is aware of what those rules are and those get recorded in the real property records. There were some changes to 209 hearing requirements. And so a lot of you probably have communities with a 209 hearing policy that needs to be amended. Voting policies, amending the fine policy, ACC solicitation policies, all of these need to be either amended or added. There was some clarity with regards to security measures. A lot of you might recall that there was a lot of confusion about security measures and in particular perimeter fencing, what the perimeter actually was and where that should be located, height, all of that sort of stuff. These things were pretty much clarified in this legislative session. And so we are going to have to make some changes to the security measures policy as well. If any of these are ones that are raising a flag for you, we can get into them in more detail on an individual basis. But if it's something that you think the association might need, reach out to us and then we can get that started for you. And those are for single family. With regards to condominiums, there are requirements for management certificates, voting, and common area use. So again, if any of these are raising a flag for you, make sure you reach out to the association's attorney to determine if the community needs them, or let us know that you in fact believe that the community does need them and we can get those prepared for you immediately. We've already kind of come up with a packet of these too, so we can send that information to you as well, and the community can decide whether or not they need them. And our takeaways for the day. So it's really important to read the governing documents, not only as a manager, but the board members need to do the same thing so that they are aware of what the declaration and bylaws actually say. And of course, it's not to have them committed to memory, but certainly so that they understand their roles as board members, things like meeting notice, 209 hearings, quorum, and things of that nature. Those are all things that board members should be very familiar with. Especially as a new board member, it might be a good idea to kind of do like a 101 or a board orientation to give them an idea of important provisions of the bylaws or the governing documents or the declaration that they need to review, but also for them to, as a reminder, let them know that they need to kind of review that document as a whole in their own time so that they can familiarize themselves with their roles. And then the other takeaway would be to make sure that the associations follow the recommendations by legal counsel, update whatever policies that need to be updated to make sure that they stay in compliance with the law. And remember that most of these new laws go into effect September 1st. So now's a good time for us to make those recommendations or suggestions to the communities that we represent to let them know that there are certain policies that they will probably need to adopt or amend in order for them to stay in compliance with the law. All right, that is all I have for you guys today. I know that I saw a couple of questions, so I'm going to go to the chat real quick and I'll take whatever questions I see here. And let's see. All right, so first question is it a requirement or recommended? Sorry, it jumped away. Okay, recommended best practice for policies to be recorded as dedicatory instruments for the policy to be enforceable. First and foremost, that is a requirement. In order for the policy to be enforceable, it must be filed or recorded in the real property records. Can a POA file a dedicatory instrument without a board vote documented in meeting minutes? So the thing that needs to be documented in the meeting minutes is that the board considered and voted on approving the actual policy itself. The meeting minutes don't have to say that the policy was actually recorded. So yes, the POA can file a dedicatory instrument without a board vote, but the dedicatory instrument itself needs to be voted on and approved by the board during an open board meeting. The next question is, what is included under books and records? So books, there's a very specific definition in the property code of what books and records are. And it has things in there like, of course, the dedicatory instruments or the governing documents. It might have tax returns and audits. It might have accounting information for all of the homeowners, a budget information and things like that. But that books and records definition is very specific. Things that fall outside of that definition are not necessarily books and records and don't necessarily need to be kept or maintained by the association. Contracts, yes, and they're in that definition, there's usually a time period for how long those things need to be kept. Your association, Brian, should also have a policy related to books and records, and it's called a retention policy, to let homeowners know how long certain documents are going to be retained by the association. So if they don't have something like that, then let us know, and we could try to get something on file for you. The next question says, does anything stop a board majority from using their majority position to put in place unvoted on verbal edicts under the guise of a policy? So the board obviously operates by majority. And if the majority votes certain things in, then there's not much that can be done to prevent that. But whatever gets voted in needs to be legally sound and in accordance with the governing documents. So if there's something that's happening that is against the law or outside of the governing documents, then that's something that could possibly be raised as a claim. Board members also have certain protections under the Volunteer Act, and as far as insurance is concerned, the D&O insurance. So that might be something that we need to talk about separately, Tom, if you're having issue with the community like that. Okay, so Gary says, do condos without a management company need a website to post the governing documents too? So yes, and I think that there might be a unit limit, which I'm not sure off the top of my head, but it is best practices to go ahead and have a website to post those governing documents. Gary, I can look at whatever provision in Chapter 82 to confirm that if you want to send me an email. All right, I don't have any other questions. So I'll give like a couple seconds for anyone else to ask any other additional questions. But if we don't have anything else, thank you guys so much for joining me today and giving me your lunch hour. Hopefully this was helpful. Hopefully you learned some good information. And if you guys have any other questions, you can reach out to us, scan that QR code to get my contact information. And hopefully I'll see a couple of you guys at the Take a Manager to Lunch event on Thursday. But if not, see you soon. Have a great week and try not to burn up. I know it's super hot outside, so talk to you guys soon. Bye.